Hi, Gary DeWall here, and this is Bridging the Week for October 6th to 10th, and today is October 13, 2014. Good morning. Indeed, it's an especially good morning for those in the United States who have today, Columbus Day, off as a holiday. Not me, I'm jealous. In any case, London Metal Exchange approved warehouses and other foreign matters, including a surprise disclosure regarding a contentious international issue by the new Commodity Futures Trading Commission chairman, took the spotlight this past week in developments related to the financial services industry. And has anyone seen some missing Securities and Exchange Commission laptops? Well, work or no work, we have some news to cover for last week, so let's get started. The UK Court of Appeals held that the London Metal Exchange may proceed with a previously announced plan aimed at shortening the amount of time it takes to retrieve metal from exchange-approved warehouses. In doing so, the court set aside a lower court ruling on this matter. During 2013, the LME was criticized for delivery days from LME-approved warehouses that some claimed were artificially increasing the price of certain LME-traded metals worldwide. In response, on November 7, 2013, the LME, after public consultation, proposed a rule that would link the amount of LME-traded metal an exchange-approved warehouse could accept for storage to the amount of the same metal it released whenever the warehouse could not process requests to discharge the same metal from storage in less than 50 days. As you may recall, United Company Rusal plc, an aluminum producer, challenged the consultation process. The company claimed that the LME's proposed rule would financially hurt producers like itself, and that the LME never adequately considered this potential harm as it was required. In holding for the LME, the appellate court rejected Rusal's claims and concluded that the exchange's consultation process regarding the so-called LILO rule was adequate. In response to the appellate court's decision, LME announced it would proceed with a 2-week consultation and expected to implement the new LILO rule on February 1st, 2015. The Commodity Futures Trading Commission hosted a meeting of its Global Markets Advisory Committee, chaired by Commissioner Mark Weechin. The principal topics included when the Commission should begin mandating the clearing of foreign exchange-based non-deliverable forward contracts and unique regulatory issues presented by exchange-traded derivative contracts based on bitcoins. Most surprising was the unrelated announcement by Chairman Timothy Massad during his opening remarks that European regulators have, quote, decided to postpone the imposition of higher capital charges, end of quote, that had been expected as of December 15 because of their failure to date to recognize U.S.-based clearinghouses as so-called qualified central counterparties. In his opening statement, Mr. Weechin observed that there are conflicting views regarding the timeliness of an NDF clearing mandate. However, whatever the decision regarding the timing of a clearing mandate, Mr. Weechin urged that, quote, the implementation of any such mandate be aligned with any comparable mandates overseas, end of quote. Last week, you may recall, ESMA began consultation on a European NDF clearing mandate. Separately, Mr. Weechin observed that already one Bitcoin-based derivatives contract has been proposed by a swap execution facility, Terra Exchange LLC, and other registered and pending registered platforms intend to list other Bitcoin-denominated contracts soon. The discussion of the GMAC dealt with, quote, regulatory challenges that these novel contracts present, end of quote, as well as, quote, potential benefits that Bitcoin or Bitcoin-like protocols and technology, end of quote, might introduce to derivatives marketplaces. By the way, speaking of Terra Exchange, last week it announced that the first Bitcoin derivatives transaction had been executed on its trading platform involving a US dollar Bitcoin swap. The UK Financial Conduct Authority announced sanctions against 2 former directors of Pritchard Stockbrokers Limited related to the firm's mishandling of client assets. Pritchard was a UK-based firm designated by the FCA to carry out an investment business that was engaged in stock brokering and wealth management businesses. The 2 former directors were David Gillespie, the company's former managing director, and David Welsby, the firm's former finance director. According to the FCA, Pritchard experienced financial problems since 2009. FCA claimed that from July 1st, 2010 through February 8th, 2012, except for 2 days, Pritchard had significant shortfalls in client money. In response, Mr. Gillespie allegedly obtained an undocumented offshore facility to buttress the firm's client money position. However, this offshore facility was impermissibly included as an available client money resource by Pritchard and Messrs. Gillespie and Welsby. To resolve this matter, Mr. Gillespie and Mr. Welsby agreed to nominal fines in light of their quote-unquote verifiable evidence of serious financial hardship, and to be barred from ever being involved in an FCA-regulated activity. Pritchard would have been subject to a financial penalty of almost 5 million Great British pounds, or over $8 million US dollars, said the FCA. However, the FCA determined that, given the financial situation of the firm, any funds should be made available to creditors and, quote-unquote, decided not to impose a financial penalty upon it. Freeburg Mercantile Group, a Canadian-based registered futures commission merchant, was fined $70,000 US dollars by the Commodity Futures Trading Commission for having an insufficient amount of funds in its so-called customer secured account origin on one day, and for not responding to the CFTC's deficiency on the same day as required. According to the CFTC, on February 5, 2013, a Freeburg Mercantile customer requested a transfer of $300,000 US dollars from its so-called segregated account, which is to support U.S. futures and options, to its secured account, which is used to support non-U.S. futures and options, to cover a margin call. As a result of some erroneous attempted transfer of funds to accommodate the client's request, the firm had insufficient funds in its customer secured account origin to meet its secured funds obligations to its customers. Freeburg Mercantile voluntarily consented to the settlement. And finally, 2 subsidiaries of E-Trade Financial Corporation were sanctioned by the Securities and Exchange Commission for permitting 3 unnamed customers to sell to the public newly issued penny stocks that previously had been deposited in the E-Trade accounts without any registration statements for such securities being in effect. As you may recall, distribution of securities without registration statements or a valid exemption being in effect are unlawful. According to the SEC, at various times between March 2007 and April 2011, the E-Trade companies failed to conduct appropriate due diligence to identify a lawful exemption that might be in place, and as a result, facilitated the unlawful sale of penny stocks of approximately 247 different companies. Moreover, the E-Trade companies are alleged to have missed several red flags which the SEC claims should have, quote, raised the question as to whether these customers were engaged in an unlawful distribution, end of quote. Those darn red flags, once again. The E-Trade companies agreed to settle this matter by remitting an aggregate penalty of $1 million US dollars and paying back more than $1.5 million US dollars in disgorgement and interest from the impermissible sales. Well, that's it for this week's issue of Bridging the Week. As always, there are more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWall. Have a great week. If you're lucky enough to have today off, enjoy. And for the rest of you and all of you, ciao!